Historically, conscientious objection concerned only the military service because it was the only area where a person could legally be required to kill another. However, in the past decades, laws have been voted that allow other exceptions to the prohibition of killing, placing some people, especially in the medical area, in a situation where they are required to end someone else's life. This is the case with abortion and euthanasia. So also, although the majority of the case law and documents on conscientious objection concern the military service, objection is not limited to this area. It concerns every profound conviction arising from religious, ethical, moral, humanitarian, philosophical, or similar motives. That's a quotation of the Parliamentary Assembly of the Council of Europe, especially within a context in which it may be necessary to deprive another human being of life, according to the Human Rights Committee. Normally, conscientious objection should have no reason to be claimed in the medical area, because the aim of medicine is to cure, and no medical professional in conscience may refuse to cure anybody. All medical professions aim at protecting life by promoting health. However, the scope of medical action has changed in the past decades. Various actions that are not therapeutic have been included in medical activities. This began with contraception, developing with other non-therapeutic activities, quite varied, from plastic surgery to sterilization, for example, and eventually encompassing abortion and euthanasia. As the very nature of medicine was altered, the law provided conscience clauses to guarantee that medical staff would not be obliged to participate in those non-therapeutic activities. So strictly speaking, these clauses are not conscientious objection because there is no obligation to participate in these activities. However, some recent developments suggest that situations leading to real medical conscientious objection are developing, as medical staff are increasingly required to participate in these non-therapeutic activities. So the problem does not lie in the individual conscience of the objector, but on the act that is demanded, which falls out of the normal or traditional scope of medicine and contradicts human life or dignity. So conscientious objection is not based on a subjective opinion, which could be more or less arbitrary, but on the act at stake, which objectively affects life or human dignity. And when life is at stake, a conscientious objection may be claimed. The right to freedom of conscience of members of medical professions, including their right to refuse to perform activities or to participate in them, is generally recognized both at the international and national levels, and is also well settled in professional ethic rules. These rules insist on the duty of medical staff to act in conscience, and consequently on their right not to be obliged to participate in the procedure they don't agree with. At least since the Hippocratic Oath, medical professionals must practice their profession with conscience and dignity, maintain the utmost respect for life, and they have the right both to undertake and refuse to undertake medical procedures according to their personal conscience. That's in professional ethic rules. And the situation is similar for other medical professions like midwives or pharmacists. The fundamental principle guiding the conscience of all members of professional health professions is respect for life. At the international level, conscientious objection is well established now, and in Europe it has also been asserted, especially by the Parliamentary Assembly of the Council of Europe in several resolutions. And these resolutions manifest the consensus on the state of the law and practice in Europe, which comes very close to the definition of customary law. So we can consider that conscientious objection is part of, or becoming part of, customary law. The case law of the ECHR has also repeated that freedom of conscience in the workplace has to be respected, and as has just been said, imposes on the state the obligation to reconcile conquering rights. And the court has also ruled that the possibility to change job was not sufficient effectively to protect the right to freedom of conscience. The right of doctors not to participate, doctors, midwives, etc., not to participate in procedures they disagree with, is also recognized at the national level. In European countries where abortion or euthanasia in some rare countries have become legal, it's only under strict conditions, otherwise it remains a criminal offense. So abortion and euthanasia are clearly exceptions to the prohibition of killing, and the law clearly says that no one can be forced to participate in them. This freedom of conscience is guaranteed in almost all European countries. Only 5 European states do not include freedom of conscience of medical staff in this protection. These countries are Bulgaria, the Czech Republic, and 3 Nordic countries, Iceland, Finland, and Sweden. In all others, it's protected. However, it may and does happen that some law order health professionals to perform acts that are contrary to the aim of medicine. Some people consider abortion as a right, not as an exception to the right to life. This view is not founded in medical ethics, where it is clearly an exception, and is not founded either in international law or in most national laws. It's a faculty, it's a possibility, but it's not a right. No treaty recognizes abortion as a right. The document that went the furthest is the Cairo Conference, but this document says that abortion should not be promoted as a method of family planning, and repeatedly called on states to prevent abortion and help women avoid it. And the ECHR, the European Court of Human Rights, has also repeated that Article 8 cannot be interpreted as conferring a right to abortion. Once again, it's a possibility, but it's not a right. And most national laws also expressly state that life must be respected. Abortion and euthanasia are acceptable only under strict conditions, and they are not fundamental rights. However, there is a trend which claims that there are individual rights, and this trend influences the law and the interpretation of the law in some countries. The first one, which we can mention, is Sweden, already mentioned, where abortion and abortion is considered a right, a fundamental right of women. Therefore, medical staff cannot refuse to participate in it. The consequences are very far-reaching. Students do not get their diploma. Gynecologists cannot work in hospital, do research, or teach if they refuse to perform abortions. Midwives can't find a job either. The case of the midwife has already been mentioned. She lost her job, her contract was not renewed, then she could not find another job in another hospital. She went to court and lost her case, and now she has left and gone to Norway. In Sweden, she could only become a nurse, no more exercise her profession of midwife. But we also have cases of creeping discrimination or an outward constraint on medical staff. For example, in France, the right not to participate in abortion is theoretically protected, but in practice, public hospitals are obliged to perform abortions, and as very few doctors or midwives are willing to do it, they have to take that in turn and do it in turn. So it's very difficult for them to exercise the right, even if it's guaranteed by the law, not to participate. The problem arises also with pharmacies. When the law on abortion was voted, abortion was only surgical, so pharmacists were not concerned. But now it's chemical, and they have no conscience clause in the law, so they have to sell abortive products. And recently, a young pharmacist lost her job in France because she refused. She asked a colleague to sell these products, and she didn't want to do it herself. But the client got the product, but she did not do it herself, and she lost her job. We have other examples in the UK and other places. Until recently, this trend concerned only abortion, But a recent case in Belgium suggests that the same could follow about euthanasia. A nursing home refused to let a physician come in to euthanize a patient. Finally, the patient went back to her home and was killed there. But now her children are suing the nursing home because euthanasia could not take place there. So they say it increased their mother's suffering in the end. As a conclusion, termination of life is a fact. It's not a matter of religious belief, but of morals. Objectors can be of any religion or none at all. It's interesting to see that the first documented case of conscientious objection in history concerns midwives. In the 14th or 13th century before Christ, when Pharaoh ordered Hebrew midwives to kill all male newborns, and they did not obey. So that was before the time of Moses, so before the Ten Commandments, thou shalt not kill, which shows that respect for life is part of the moral law printed in human conscience, independently from religion. So the right to conscientious objection stems directly from freedom of conscience, from the conscience ability to adopt moral convictions on what to do or not to do, on what is good or not good. It is a right not to take part against your will in the voluntary termination of a human life, even if such termination is legal. Legalizing abortion or euthanasia is one thing. Obliging individuals to perform them against their will is another. Recognizing the right not to be forced to participate in them does not affect the legality of abortion or euthanasia, or the possibility to have access to these procedures. Democratic states claiming to protect and promote human rights cannot refuse protection of one of the most fundamental human rights, freedom of conscience, to a category of population, namely the medical professions, because of their convictions, their moral judgment on what they should do or not do. Thank you.
Thank you very much.